Hello, good evening. Am I audible? Surya, are you there? Am I audible?
Yes, sir, you're audible.
Okay, okay. Thank you. Thank you.
Good evening, sir.
Good evening, sir.
Good evening.
Good evening, sir.
Hello, good evening. Am I audible? Good evening. Yes, yes, thank you, thank you, thank you. It's good to see you this boardroom. I don't know how many were there in last time.
Am I
Last
audible?
program.
Yes, sir, you're audible.
Last program, short skill we did. I don't know how many were there.
Good evening, sir.
Good evening, sir.
Good evening, good evening. Thank you.
Hello, good evening, am I audible? Yes, yes,
Just Surya, and then I don't know. I don't know the face.
I don't know how many were there last time. Muted. Yes, sir.
Last program, short skill we did.
Tap it. Something wrong.
Good evening, sir.
Good evening. Hello. Yes, Surya, am I audible properly? Hello. Surya, am I audible?
Sir, you are audible, sir. You can continue.
Okay, okay. Thank you, thank you. I hope it's not breaking. Thank you.
Okay,
Audio issue.
Our history of the case now.
Sir, are we audible to you?
Full history. Full history. Eco survey.
Hello.
Are we audible to you, sir?
Yes, you're audible, audible. And VC sir has joined. Please make him co-host.
So who can we make the co-host?
Fan on ಮಾಡ್ರಿ.
No, host will be able to make. So please do it. And the voice is not that much clear.
Video on. Yes, please, sir.
Yes, Vani ma'am. Good evening, ma'am. Thank you.
Namaste, good evening, sir.
गुड इवनिंग
Good evening.
कल्पेश जी, कैसे हो
Thank
आप?
you, thank you, thank you, ma'am. Thank you. Good to see you this you all again and this
नाइस
boardroom.
टू मीट
I
यू.
love this
यस
boardroom.
Sir, namaste, sir. Baswaraj, sir. Baswaraj,
Uh,
sir. Baswaraj, sir is there.
he's to
he's
unmute
there.
it.
He's there.
Yes.
One second, we'll take permission of the VC and then we start. Maybe one second. Put it to that side now. I didn't want the
Okay,
front
yeah.
one.
Sir, are we audible to you, sir? Baswaraj, sir? I think sir is trying to speak because of network. It is not getting.
But they have unmuted. We can.
Hello.
Sir, namaste, sir.
Namaste, ma'am. 2 minutes, ma'am.
Yes, sir. Yes, sir. Please take your time. Mohan, sir.
Okay.
ಸರ್ ಆ ಕಡೆಗೆ ಈ ಕಡೆ ಡೈರೆಕ್ಷನ್ ಇಲ್ಲ ಸರ್ ಈ ಕಡೆ ತೆಗೆದ್ಬಿಡಿ ಸರ್ ಬುಕ್ಸ್
Hello, Basavaraju sir. Good evening, sir. Welcome, sir.
Good evening, good evening.
Sir, sir, good to see you again, sir.
Namaste, good evening, sir.
Good evening. Namaste, ಎಲ್ಲರಿಗೂ ನಮಸ್ತೆ.
Namaste, sir. Nice to see you, sir.
Thank you, Ma.
Sir, with your permission, shall we begin, sir?
You can start now.
Thank you, sir.
Good evening, distinguished guests, esteemed faculty and participants. I am Ananya. I am from JSS Law College and I have the privilege of serving as your host this evening. On behalf of JSS Law College Autonomous Mysuru and Pro Bono India, I extend my heartfelt gratitude to each of you for your presence at this significant occasion. It is my distinguished honor to welcome you to the 10-day capacity building program on alternative dispute resolution, legal aid, and allied laws. I would especially like to acknowledge our eminent dignitaries who, despite their demanding schedules, have graciously joined us today to inspire and encourage our participants. In our cherished Indian tradition, we begin by seeking divine blessings before embarking on any meaningful endeavor. It is my pleasure to welcome Ms. Amrita, a first-year BBLLB student, to grace us with an invocation song. Stand here. Yes. ಪೂಜಿಸಲೆಂದೇ ಹೂಗಳ ತಂದೆ ದರ್ಶನ ಕೋರಿ ನಾನಿಂದೆ ತೆರೆಯೋ ಬಾಗಿಲನು ರಾಮ ತೆರೆಯೋ ಬಾಗಿಲನು ರಾಮ ಪೂಜಿಸಲೆಂದೇ ಹೂಗಳ ತಂದೆ ದರ್ಶನ ಕೋರಿ ನಾನಿಂದೆ ತೆರೆಯೋ ಬಾಗಿಲನು ರಾಮ ತೆರೆಯೋ ಬಾಗಿಲನು ರಾಮ ಮೋಡದ ಮೇಲೆ ಚಿನ್ನದ ನೀರು ಚೆಲ್ಲುತ್ತ ಸಾಗಿದೆ ಹೊನ್ನಿನ ತೇರು ಮೋಡದ ಮೇಲೆ ಚಿನ್ನದ ನೀರು ಚೆಲ್ಲುತ್ತ ಸಾಗಿದೆ ಹೊನ್ನಿನ ತೇರು ಮಾಣಿಕ್ಯದಾರತಿ ಉಷ ತಂದಿಹಳು ಮಾಣಿಕ್ಯದಾರತಿ ಉಷ ತಂದಿಹಳು ತಾಮಸವೇ ಕಿನ್ನು ಸ್ವಾಮಿ ತೆರೆಯೋ ಬಾಗಿಲನು ರಾಮ ತೆರೆಯೋ ಬಾಗಿಲನು ರಾಮ. Thank you, Amrita, for that exquisite rendition. Your soulful performance has truly touched our hearts and set a serene tone for our proceedings. I now have the honor of inviting our respected principal, Dr. N. Manishri ma'am, to deliver the welcome address.
A very good evening to one and all present here, both online and offline, to this 10-day online capacity building program on ADR, legal aid, and allied laws to commence from today, that is the 7th of April, and of course, culminating on the 17th of this month. Jointly organized by Pro Bono India and JSS Law College, Autonomous Mysuru. And it shall be my great honor to do the welcome. And before that, I'm not going to take away the time and the scholarly views of the great professors who are here and will be addressing, but then trying to just share with you all about the importance of ADR, legal aid, and in the legal context, the allied laws. Basically, ADR, which refers to the different ways that people choose to resolve disputes without a trial, and some of the common ADR processes, which I think will be going through the next 10 days. And these processes generally are more confidential, less formal, less stressful than that of the traditional court proceedings, including that of the Lok Adalat. Legal aid, as we are aware of, and the most basically, is the provision for assisting the people who are unable to afford legal representation and access to the court system. And also it's regarded as a central, it is central to providing access to justice by ensuring equality before the law, and also the right to counsel and the right to a fair trial. Allied laws generally refers to a group of laws that are related to or complementing to the main primary law, often covering similar or related areas of legal regulation. Now, I wanted to give my very briefly about the views, because what a combination and the thought and the conceiving of the idea of combining ADR, legal aid, and other allied laws is a wonderful thought. Apart from, we've seen pro bono doing a lot of programs, including that of IPR and almost all the areas they've covered up. This is, I think, one of its very exquisite one. And thank you for conceiving of such an idea. Nextly, without taking more of the time, at the outset, I would like to welcome Professor Dr. C. Baswaraju, sir, Honorable Vice Chancellor, Karnataka State Law University, Hubballi, for his very, very valuable time, I would say, because we are all aware of how busy schedule he has throughout. I think 24/7 is less time for him to complete his job as the Vice Chancellor. And thank you for that, sir. And who will be doing very shortly the honors of inaugurating this academic program with us. Thank you, sir, and a very warm welcome to you, sir.
Thank you, Professor Vanishri.
I would like to share that he is my teacher, my guide, my mentor, who has guided me through my PhD work as well. This is out of pride. I'm sharing it with the others who don't know about this. Nextly, Dr. Kalpesh Kumar L. Gupta, founder Pro Bono India, who has assisted us in coordinating and organizing this program. I still remember the struggle that Kalpesh ji had when he started off with all the law teachers. We were with him. He was sending an email to the JSS Law College as well. I'm talking about my former principal, Dr. S. Nataraju sir, where he brought in all the law teachers from the north, up north, to the down south, east and west, bringing them all together. And, whatever he is doing today is the proof of his efforts, which we acknowledge, sir, and a very warm welcome to you. Thank you for choosing our college, sir, for coordinating these great academic endeavors.
Thank you.
Nextly,
Thank you very much. Thank you.
I also welcome our Chief Executive, Professor K. Suresh, sir, in his absentia. I extend a very warm welcome to our senior faculty, Professor Nagendra Murthy, sir, who is the course teacher for ADR, and Ms. Asmatunnisa ji, who is the faculty coordinator and also the course coordinator to one of the final year classes, without whose help, I don't think this would have been possible. And of course, all my other faculty members, teaching, non-teaching, and especially the scholarly resource persons who are going to guide us through these 10 days. A very warm welcome to them as well. The faculty who participants, student participants, both UG and PG courses, and all the participants to this program in common from all the colleges, including ours, a very warm welcome to you. Last but not the least, to the beloved student coordinators, some of them who are with us here and some of them behind the screen, without whose active involvement, this program, especially the inaugural session and the 10 days program to go on, will have a smooth flowing and will definitely be a successful one. Once again, I deem it a great pleasure and a warm welcome to one and all present to this academic endeavor. Thank you all.
Thank you, ma'am, for your inspiring words of welcome and wisdom. I would now like to request Assistant Professor of Law, Ms. Asmatunnisa ji, who is also a co-organizer of this program, to introduce our distinguished chief guest, Professor Dr. Honorable Vice Chancellor, KSLU.
Thank you, Ananya. Good evening to the esteemed guests, enthusiastic participants. I feel blessed with the role of introducing my guru. Guiding light to many, who has touched the life of countless, he is none other than Professor Dr. C. Baswaraju, who is presently working as Vice Chancellor of Karnataka State Law University, Hubballi. He was also ex-Vice Chancellor in charge former registrar, syndicate member, an academic council member in the University of Mysore, and former registrar evaluation, Karnataka State, Dr. Gangubai Hanagal Music and Performing Arts University, Mysore. From his student days, he has committed himself for the amelioration of social cause of the society and has been fighting for cause of social justice for all in general, weaker and vulnerable sections of the society in particular. During his student days, he worked as General Secretary and President of Student Union in Sharda Vilas Law College, Mysuru from 1987 to 1989. The academic records of Professor Dr. C. Baswaraju, Honorable Vice Chancellor Sir, is very impressive. He has obtained his PhD degree in Social Justice, LLM degree in Constitution Law, MA degree in English Literature, LLB degree in Law, and BA degree in English Literature from the University of Mysore. He has obtained gold medal in BA from the University of Mysore. Having considered his academic credentials, he has been nominated as member to the National Assessment and Accreditation Council, Peer Team, Bengaluru, and visited more than 15 universities and 25 colleges for assessment and accreditation. By Honorable Professor Dr. C. Baswaraju Sir is a law teacher known for his commitment, honesty, integrity, and dedication in his profession. He has made his contribution to the field of law through publishing more than 125 research papers in both national and international academic journals. He has published 4 books which are most significant for the legal profession and academia. He has presented more than 175 research papers in both national and international seminars, conferences, etc. Sir, focus is mostly on social justice with special reference to SC and ST under the Constitution of India. Sir, thesis has been published in the form of book by Serials Publication, New Delhi. He has completed 2 major research products funded by University Grant Commission, New Delhi. Professor Dr. C. Baswaraju has a scholarly presentations of research papers in both national and international seminar, conferences, workshops, etc. Sir has been invited to Poland and he has presented a research paper at an international conference on environmental best practices in India and the role of the judiciary, for which he was awarded Best Paper Presenter Award. He has also visited the Supreme Court of Bhutan and held deliberations with the justices of High Court and Supreme Court of Bhutan. Sir has also visited Dubai and presented a paper on the role of higher and different perspectives in contemporary issues, and at the international conferences by South Asian countries organized by Anglia Ruskin University, United Kingdom. He has also presented a paper on the role of higher education in promoting good society at the University of Guangzhou, China. As a committed professor in his profession and the progress to the society, Honorable Vice Chancellor Sir started his academic career as a law teacher in the prestigious Institute for National Law School of India, University, Bengaluru in 1995. Later, he shifted to the Department of Law and Research, University of Mysore. Sir was also my guru and I still remember his jurisprudence classes. Sir has produced successfully 18 PhD candidates and at present 8 PhD students are working under his guidance. Besides, he has adjudicated more than 95 PhD theses at various universities. Sir has organized various symposiums on human resource, right to information laws, national integration laws, and lot many more. Professor Dr. Baswaraju has obtained wide administrative experience as a Dean, Faculty of Law, Director, School of Law, Vice Chancellor, In-Charge Registrar, University of Mysore, Registrar Evaluation at Karnataka State, etc. He has also worked as a chairman and member of many statutory bodies like Syndicate, Academic Council, Board of Studies, Board of Examination, Malpractice and Inquiry Committee, etc. With this brief introduction, Professor is also presently associated with various non-governmental organizations for the cause and social justice to vulnerable sections of the society and promoting national integration to the youth community. He is also a member of Karnataka Bar Council, Bengaluru and Mysore Bar Association. Sir, it is my privilege to introduce my guru, sir, and I feel very less about myself to give a brief profile of yours, sir. Sir, I wholeheartedly welcome you to this particular conference. Thank you for joining us, sir.
Thank you, Ms. Asmatunisa, for your introduction.
Thank you, sir. And
Thank
I
you.
just want to take 2 minutes of time to introduce Dr. Kalpesh Kumar Gupta also.
You can.
Only Take only 10 seconds. There is no need to introduce
okay,
me.
sir.
I'm a law teacher only. No,
Dr. Gupta
thank
is a distinguished law teacher and research with 2 decades of experience spanning both in industry and academia. He has served prestigious institutions such as Indian Institute of Management, Allahabad, Gujarat National Law University, Gandhinagar, etc. Dr. Gupta's academic leadership extends further. He has contributed significantly to Parul University, Vadodara, and Oro University, Surat, inspiring countless students in the discipline of law and management. Under his mentorship, 30 LLM students and 3 MPhil scholars have been successfully completed their research journeys. And presently, he is guiding 5 scholars of PhD. As a visionary entrepreneur, Sir has also founded the platform like Pro Bono India, Legal Startup, Court Management India, Law Teachers India, etc. Brief introduction. I also
No problem. I am muted. I am muted.
Yeah.
yes, sir. Sir, thank you for joining us, sir.
Thank you.
Kalpit,
Thank
sir.
you. Thank you very much for this. Again, second opportunity for us to plan this particular program. Over to you.
Thank you, ma'am, for that comprehensive introduction of our guests today. It is now my privilege to invite our esteemed chief guest, Professor Dr. C. Basavaraju, to address the gathering and formally inaugurate this program.
Good evening to one and all. Good evening to one and all who are on the online mode. Today's distinguished Dr. Kalpesh Kumar L. Gupta, founder, Law Teachers India, Chief Executive Officer of JSS Law College, and a former principal, Professor K. Suresh, principal of JSS Law College, and my student, Dr. N. Vanishri. Then the coordinator, Miss Asma Tunisa, assistant professor, JSS Law College. My dear friend and my classmate, Professor Nagendra Murthy, who is the real person behind this conducting of this program. And also all my students, all the invitees, participants, ladies and gentlemen. Today I am so happy that the JSS Law College, in association with the Pro Bono India, is jointly organizing 10-day online capacity building program on ADR, legal aid, and allied laws for a period of 10 days from 7th April to 17th April. I think this program, especially focusing upon the capacity building program on alternative dispute resolution, really has fascinated many academicians, many practitioners, and also many publics, so that the capacity building of individuals needs to be focused on various issues to inculcate some of the basic skills, skill of understanding, skill of listening, skill of resolving the disputes, skill of analyzing the issues. These are all the skills needs to be inculcated to our young generations of students. In the capacity building, what is required is that we need to tap the skill of the students so that whatever the skill, hidden skill they have in finding out the problems of the society, identifying these as problems, identifying the remedies for them, and the way in which they all needs to be resolved, It's a challenging task of today. Today, after 75 years of constitution came into force, we have been still depending upon the judicial institutions. Judicial institutions which are established under the constitution, providing for justice to the people in general and vulnerable sections in particular. And of course, the formal litigation, the formal process of a litigation which takes place in the judicial institution or courts are playing a very important role in adjudicating and dispensation of justice. And of course, the role of courts today is well appreciated and well prized for the simple reason that the courts, they are playing a crucial role in upholding, protecting, safeguarding the rights of the people of this country. And especially the rights of the vulnerable sections of the societies, the marginalized groups, women and children, laborers, farmers, poorer sections of the society are also to be protected from the onslaught of the various individuals and institutions. And today's program of this 10 days capacity building on alternative dispute resolution mechanism and legal aid programs are of very important today in providing justice to the people in general and vulnerable sections in particular. Why do we require this alternative dispute resolution mechanism when we have a litigation, a formal litigation system? This formal litigation system has been there since many years. And justice delivery system is through this formal litigation system, wherein the affected parties, the aggrieved parties, they need to approach the courts, engage a lawyer, and content the case. He has to make a contention of his dispute. And every litigant who enters the pedestal of court always looks at the court with great humiliation, with great respect, decorum, and dignity, because they expect justice from these institutions. But over a period of time, it is due to the explosion of population, it is due to the explosion of the cases, litigations, disputes, and also due to the development of civilization, transportation, industrialization, and business activities, the litigations have reached to the pinnacle. There are thousands and thousands of litigants. They are still waiting for the justice to get. It is because of the fact that our courts are overloaded with the litigations, different litigations. It could be civil litigations, it could be criminal litigations, it could be litigations on violation of intellectual property rights, it could be violation of the rights relating to land, property, and so on and so forth. So today, the courts are flooded with the various cases, innumerable cases, as a result of which it is very difficult to get justice at the earliest. But common people who have approached the courts to seek justice, they never get justice at a shorter time because of the flooding of cases. Then what is to be done? And what is the role of this courts, judiciary. The role of the judiciary is to protect the interest of every individual, safeguard the rights given under the Constitution and various other laws. At the earliest, if this is not done by the judiciary, then what is for judiciary? How long the judiciary should take care or take time to dispose of the cases? An ordinary man or a common man or a marginalized sections of the societies, they may not wait for a long time. We have been seeing today that a person who enters the courts with litigation, by the time he attains the age of 70 years or 80 years, sometimes 90 years, his litigations will not be cleared or resolved. And that is the pathetic condition in which the Indian judiciary we are witnessing today. So therefore, we need to find out an alternative way, an alternative mechanism to resolve our disputes. If the settlement of a dispute or resolving of the dispute in the formal litigation form takes a longer time, takes more time, then we need to look at the alternative mechanism, the alternative way, how best we can resolve our disputes at the earliest. You may be knowing that the people who enter the courts with a formal litigation, they not only lose money, but also they lose patience. They also sometimes lose even confidence on the judiciary when the litigations are delayed unreasonably. So therefore, in the recent past, and especially in the year 1987, the Legal Service Authority Act was passed by the Parliament, in which the authorities were established at the national level, at the state level, at the district level, at the taluk level. The legal service authorities were established. And what are the functioning of these legal service authorities? The functioning of the legal service authorities is to help the poorer sections of the society receiving the complaints, receiving the litigations, and directly, in fact, resolving the disputes by calling both the parties, whether the parties belong to the government, whether the parties are individual, in whatever may be the capacity. The legal service authorities, it plays a very crucial role in resolving the disputes without entering to the court. So therefore, a new mechanism has been devised in the recent past. The new mechanism is alternative dispute resolutions. Even at the international level, also we find this international alternative dispute resolutions of international disputes. So also in India, we have a alternative dispute resolutions. Let us have an alternative mechanism. Every individual cannot wait and rely only upon the court. If every litigation is taken to the court, courts will be overburdened. Courts will be overburdened. And the time which takes, if the time is taken by the courts, is too long to resolve the disputes. And the litigants, the poor litigants, they cannot wait for years and years together. And they are not able to spend more and more money to the litigations to continue for a long time. So therefore, now we have alternative mechanisms. The alternative mechanisms are, we have mediation, arbitration, conciliation, and negotiation. So these alternative mechanisms or alternative dispute resolution system plays a very important role in resolving the disputes outside the court. Every litigant anticipates that his litigation should be resolved. His litigation should come to an end at the earliest. If this is not if this is not done, or if this does not occur, then sometimes he will lose faith on the very process of litigation itself. So therefore, what is to be done? Even the courts are not able to dispose of the cases because of the enormous cases pending before the courts. Millions and millions of cases still pending before the various courts, including the Supreme Court and various high courts. So therefore, in order to resolve the disputes quickly with less cost, because the litigants need not spend more money, the litigants need not spend more money for continuation of the litigation as in the formal way. So therefore, this system of alternative dispute resolution is flexible. It is a flexible method in which it is totally against, or totally, in fact, totally it is acceptable and comfortable for the litigants who are not able to approach the court for various reasons. See, nearly 70% of the litigants, they are poorer sections of the society. Either for committing any small mistakes, small wrongs, all crimes, they are involved in these litigations. Either civil litigations, criminal litigations, or family litigations, property litigations, and so on and so forth. See, therefore, this system is very flexible method compared to the traditional one. Traditional system was so rigid that we have to undergo all kinds of formalities. By the time you undergo all kinds of formalities, that is examination, cross-examination, then giving time, then appointing a lawyer or an advocate, then paying the fee charged by the advocate. See, all these things, in fact, they are very cumbersome. Even after this cumbersome procedure is completed or resorted to, whether the litigants are going to get justice at the earliest? No. So therefore, now we have come to this alternative dispute resolutions system. This alternative dispute resolution system, it retains a good relationship between the litigants, unlike the litigants you find in the formal litigation. Because the proceedings of this mediation, the proceedings of this conciliation, or the proceedings of the negotiation, it takes place outside the judicial institutions, outside the courts. When it takes place outside the courts, then it is possible to maintain the relationship between the two litigants through mediations, through negotiations. So therefore, it reduces the, moreover, it reduces the backlog of cases. Backlog of cases. If the majority of the cases are settled outside the court, then there will be a little relief to the courts to take care of the rest of the cases which are in the courts. And moreover, this alternative dispute resolution mechanisms, in fact, it is faster. It is more faster. The procedure is most faster than that of the court proceedings. As I told you, court proceedings, sometimes it may take 10 years, it may take 5 years. Sometimes it may take, if it is a civil litigation, it may take 30 years or 40 years. Sometimes the litigants will not be there by the time the case will be disposed of. So these are all the very unfortunate situations which we have been seeing in the judicial development. It is because of the overburdening of the courts as a result of the plethora of cases going to the courts. So therefore, in order to avoid the prolonged proceedings of the courts and also the financial losses incurred for the litigants, it is better to have an alternative dispute resolutions through mediations. Better to get our disputes resolved through mediations, through negotiations, or through conciliations. So therefore, through this mechanism, we can ensure the speedy dispensation of justice. Justice can be dispensed maybe within 2 months or 3 months or even within 1 year. Sometimes within 2 days it can be dispensed. Justice can be provided through this mediation or even negotiations or conciliations. So therefore, this system, in fact, it enables the parties to settle their disputes amicably outside the litigation process. Everybody would like to see that their cases must be disposed at the earliest. And everybody should see that, every litigant should see that there shall not be any enmity increases. Relations should always retains good relations between the litigants. But unfortunately, whoever goes to the formal litigations, whoever approaches the court and files a case in a formalistic manner, then the antagonism starts between the two litigants, unlike you find in the alternative dispute mechanism systems. So therefore, the alternative dispute resolution mechanism, in which the parties, they are at autonomy. The parties, they are autonomy to choose any method to resolve their disputes. It is up to them. Either they can choose, if they feel that it is convenient, that through conciliation, it is possible to resolve, they can go for conciliation. If they think that the negotiation method is very accommodative, comfortable, they can go for negotiations. If they feel that mediation process is very comfortable, they can go for the mediation. Like that, option is given. There is an option, there is an autonomy is given to the litigants to choose any of these systems or any of these methods to resolve their disputes outside the court premises. See, therefore, we have been witnessing there are number of litigations, there are number of violation of rights, there are number of violation of the constitutional rights, fundamental rights, statutory rights, and so many rights. And especially majority of the people who approaches the courts, they are found to be weaker sections of the society. Even though they are not able to sustain the expenses, sustain the litigation process, formal litigation process, still they enter the courts. So therefore, in order to avoid this kind of the difficulties faced by the litigants, they are poorer sections of the society, marginalized sections of the society, or vulnerable sections. This alternative dispute resolution mechanism is of very significant. It is most beneficial for these litigants. But look at the rights violated by the state authorities, violated by the institutional structure. Under these circumstances, how to get justice? There are millions and millions of people in this country. They are not able to approach the courts with an advocate. Engaging an advocate today is a costly affair. And entering the pedestal of a judiciary is still more very difficult for the poorer sections of the society. Then how to protect their rights? How to protect their constitutional rights, fundamental rights given to them? Justice Krishna Iyer's observation, I still remember. It is pertinent to remember at this time. Wherein Justice Krishna Iyer, in his judgment in Mumbai's Kamagar Sabha case, he said, the mere enumeration of the fundamental rights, in the Constitution of India is not suffice, unless and until there has to be some mechanism to enforce these rights when they are violated, or when they are infringed. That is exactly where we find that the poorer sections of the society, the people who are unable to afford they are unable to engage a lawyer, unable to afford to enter the pedestal of judiciary, can seek legal assistance from the state. And therefore, a legal service authorities have been constituted under the legislation, parliamentary legislation. And legal service authorities are extended to every citizen, subject to certain conditions, subject to certain requirements. This legal aid service aims to help the poor, the needy people, and also it also provides an access to justice and legal assistance. It also ensures all citizens to enjoy their legal rights. And when the legal assistance is provided to the people in general, I think then they need not go to the courts to protect their rights, to protect their interest, to protect their constitutional rights given to them. But remember, the legal aid services which are contemplated under the Legal Service Authorities Act, it also in fact provides a free legal aid services. A free legal aid services is provided to certain categories of people. Certain categories of people. For example, the scheduled caste and scheduled tribes. For example, the victims of the rape. So certain categories of people, they are entitled for free legal aid services from the state authorities, because they are not able to get justice because of their technical problems like poverty, penury, ignorance, illiteracy, and economic instability. So therefore, there is a concept of free legal aid services. There are a plethora of cases where the Supreme Court and various high courts have also recognized the free legal aid services. Today, the villagers, they may not be able to approach the courts. They can have this free legal aid services from the government. And this free legal aid services to the marginalized groups, and which is stipulated and encapsulated under Section 12 of the Legal Service Authorities Act. So therefore, through conducting legal literacy camp, organizing various lok adalats for resolving disputes through compromise, and various other mechanisms, the free legal aid services can be provided. And that is how the constitutional mandate of justice, equality, right to life, liberty can be achieved, can be ensured for people in general and vulnerable sections in particular. So this program, this 10 days program of capacity building program is a very important program in which there is a need for understanding and inculcating the skill and the art of managing the situations, the skill of communication, the skill of understanding the problems, the skill of analyzing the disputes, the skill of resolving the disputes, and needs to be provided. And adequate training should be provided. How to build the good skills to the younger generations. How to strengthen the alternative dispute resolution by the courts also. The court should promote alternative dispute resolutions by referring certain suitable cases for mediation, so that the cases can be disposed of at the earliest. Number one. Number two, the court through training programs, conducting training programs to the ADR practitioners. Today, many advocates and many law students and law graduates, they want to become ADR practitioners, so that they can render their services to the society. They can render their services to the poorer sections of the society through becoming good mediators, through becoming good conciliators, and becoming good arbitrators. And also, ADR, in fact, promotes and creates awareness about the principles of ADR, how this alternative dispute mechanism should be used in order to resolve various kinds of disputes, not only the criminal disputes or civil disputes, even property disputes, land disputes, any kind of personal disputes, business disputes, any kind of disputes can be resolved by having recourse to this alternative dispute resolution system. Likewise, by conducting educational campaigns like workshops, seminars, conferences to be conducted to highlight the benefit of the ADR. And lastly, ADR centers to be set up. ADR centers should be established so that the thousands and thousands of people who are not able to approach the courts for redressal of their grievances, redressal of their disputes or difficulties can have recourse to this ADR system. So therefore, ADR centers to be set up with the trained mediators, with the trained arbitrators, and also to handle the diverse disputes. It is not a dispute confining only to the legal disputes, confining only to the property disputes, even to the various business disputes. And therefore, for a diverse disputes to resolve, there is a need for ADR centers to be established. So therefore, this kind of a program, 10 days program, which is organized by the JSS Law College as well as the Pro Bono India, in fact, is a very important program, and really it will build the inspiration, courage, and also a kind of enthusiasm to the new law graduates, so that they can take up the task of the various the alternative dispute mechanisms like mediation, conciliation, then negotiations and all. See, much of the antagonism, much of the jealousy, much of the conflict which arises between two individuals can be reduced through negotiations. By negotiating, you can resolve the dispute. Through mediation, you can resolve the disputes. This is how the alternative dispute resolution mechanism, it plays a very effective role, and it's a very effective system compared to the traditional system. But that does not mean that the traditional system should be dispensed with that, because it is not possible that all litigations, all disputes can be resolved through ADR. Only few litigations, only few disputes can be resolved, but there are certain disputes which requires intensive examination, intensive witnessing, and intensive cross-examination, and intensive proceedings are required. So under such circumstances, there is a need for traditional litigation process. But otherwise, in order to resolve the rest of the litigations, and also especially for the poorer sections of the society, marginalized groups, this alternative dispute resolution mechanism plays a very pivotal role in resolving their disputes and to get justice what is due for them and what is provided under the Constitution of India. And I'm sure that the younger generation of today, the law students and the legal practitioners, in fact, they give more significance, more emphasis on this ADR system, so that at the earliest they can render justice without any involvement of any cost. So it is a cost-effective mechanism. There is no need to spend more and more money. Poor people cannot spend more money in order to get justice. That does not mean that justice should be a mirage for them. Justice should be a distant dream for them. So therefore, this kind of the program organized by these two very important institutions on mediation, ADRs, different kinds of ADR, legal aid program and allied laws, in fact, is a very useful for our younger generations and also the budding lawyers and our budding law students. I take this opportunity to congratulate and thank both the organization for conducting this kind of program and also for inviting me to share few thoughts by inaugurating this 10-day training program. And I thank Professor K. Suresh, who is a very eminent professor, who has built the institution very magnificently, and also under the leadership of Professor Suresh, Professor Vanishri, and Professor Nagendra Murthy, and even Professor Asmatunisa. They're all, in fact, working in the JSS Law College to see that the vulnerable sections of the society should get justice by conducting all these programs. Thank you so much. I thank you one and all for giving this opportunity to share my thoughts. Thank you so much.
Thank you, sir, for your profound insights and wisdom. We all indeed resonate with your thoughts on the significance of ADR and the need for alternative methods of resolving disputes. Your words have undoubtedly inspired all participants to approach this course with enthusiasm and dedication. As we conclude this inaugural session, I invite Mr. Surya Somasundaram to deliver the vote of thanks.
Good evening, everyone. As we come to the close of this inaugural session of the 10-day online capacity building program on ADR, legal aid, and allied laws, it is both my honor and privilege to extend a heartfelt vote of thanks on behalf of JSS Law College, Mysuru, and Pro Bono India. First and foremost, I would like to express my sincere gratitude to our esteemed guest, Professor Dr. C. Basvaraju, Honorable Vice Chancellor of Karnataka State Law University, Vili. Sir, we are truly honored to have you inaugurate this event. Your presence and inspiring words have added immense value to our program. We are equally grateful to our respected dignitaries for gracing this occasion. Professor K.S. Suresh, Chief Executive of JSS Law College. In his absentia, thank you, sir, for your continued guidance and leadership that always uplifts the academic community. Dr. Kalpesh Kumar L. Gupta, founder of Pro Bono India. Thank you, sir, for your unwavering commitment to legal aid awareness and for co-organizing this initiative with such dedication. Dr. N. Vanishri, Principal of JSS Law College. Ma'am, your support has been integral in bringing this program to life. Professor M.P. Nagendra Murthy, Associate Professor of JSS Law College. Thank you, sir, for your continued guidance and leadership. Ms. Asmatunisa Ji, Assistant Professor of JSS Law College. Thank you, ma'am, for your tireless coordination and initiating in organizing this program. Thank you, sir. Ashri S. Chakravarti, Assistant Professor of JSS Law College, for your support and guidance. We are extremely grateful to all the resources persons who will be enriching us for over the next 10 days, covering insightful topics on ADR, mediation to legal aid, technology in justice delivery, and public interest litigation. To all participants from across institutions who have joined us virtually, thank you for choosing to be a part of this capacity building journey. Your enthusiasm is what makes this event meaningful. Let us carry forward in the spirit of legal empowerment and social justice over the coming days. Thank you once again and wishing everyone fruitful and enriching program. Thank you.
Thank you.
Sir, with your permission, can we conclude this inauguration session, sir?
Yes, please conclude. Please conclude.
Thank you so much, sir. Thank you.
Thank you, sir.
Thank you, sir.
Thank you, sir.
End of our inaugural session, I cordially invite all participants to join for the first session via the links provided or for the Cisco WebEx platform. Thank you for your attention and participation.
Thank you, sir.